I think I'm going to start the recording now. We've given it a few minutes. Hi everyone. Welcome to International Refugee Law. Sorry, this is all done online. I mean, the original plan was to only have a bit next week, but as I'm sure you know, there were external reasons that made it impossible for me to get to Israel in time for this course. And so I know you generally are back on campus, and that's great, and I hope that remains the case. But we'll have to run these on online. I mean, they all get recorded as well, so I appreciate you might be on the move in one day or another, and if you can't make a seminar, then that's entirely understandable. They should be uploaded automatically to the cloud through the kind of existing mechanism. So hopefully you can catch up on whatever content you would have missed. I know this is, and that's been the case every year I've taught this, because this is an intensive course, because it's every day this week. I know some of you might have a class or two that clashes with others where you have to attend, and kind of faced with that choice. If you go elsewhere, not going to be offended. You don't necessarily have to let me know as well. I mean, it's nice if you do, but it's okay. It's the nature of these intensive courses. I've run them for quite a number of years, Hebrew, and I know that is what happens with the program. So that's fine by me. Last kind of point is the kind of related to my announcement, I think from last week. My hope and plan is to not have to use this time slot that we have for next Thursday. So to essentially have the five meetings this week, and then the meeting on Monday next week, which also will relate to the situation of, the ongoing situation of asylum seekers in Israel, where we also have a guest speaker who's going to join me in kind of conversation. Her name's Shachar Mandil. She's the coordinator of the Forum for Refugee and Migrants' Rights in Israel, and we'll be discussing essentially the past, present, and future of asylum seekers in Israel. Hopefully that will be the very last session, and but please don't make plans for the Thursday, which is timetabled at the moment, because if I see we haven't got through what I think we should, then I might reinstate it. So just to give you that as a frame of reference. And the other thing, I suppose, before I turn to you and kind of want to hear why you're here, and what you're hoping to get from this course, is that because this is an intensive course, and we're really doing it day by day. I'm not going to be that rigid about the designation of what goes into each seminar, in the sense that I have planned, and you will see on the syllabus, as you were, six distinct iterations, and the last one, so the one related to asylum seekers in Israel, will run separately next week. But to the extent we find ourselves not having quite completed what I want to discuss today, for instance, and having a little bit of a spillover into tomorrow or what have you between the days, that might happen. I'm not going to be rigid and just say, well, this is all the time we have for this topic. So I want us to be able to have a full discussion, and there's also a degree to which some of them may take longer than others, based on experience. So I'm just alerting you to the idea that obviously the PowerPoint presentations will follow the specific topics, but the days or the time slots may not fully do so. So I think that's all by way of like initial admin. I'm not going to fully introduce myself in a full CV sense because it's on the syllabus and there's no reason to just go through my various multiple, probably too many affiliations. But I'm very keen to hear about you and why you're here. What's whether you have any background in refugee law or in engagement with refugees anywhere, this kind in Israel or elsewhere. Um, if not in refugee law, whether you have some background in international law, just for me to get a sense of how I pitch some of the discussions, whether I can assume broad knowledge about various terms that relate to international law, for instance, whether I should spend more time explaining them, etc. So that's the main impetus. So I'm just going to go by the order that people appear on my kind of sidebar. So if I can call on you, if you could just unmute yourselves and just present yourself briefly. So I've got Adiel Golden.
Hey, hello everyone. So I had maybe one or two classes about international refugee law, but I don't really have a good understanding of it.
Okay, great. Thanks.
Yeah,
Sorry, and what program you're in? Are you in the LLM? Are you in the undergraduate?
LLM.
The LLM. Okay, great. Fantastic. Avia Cohen?
Yes, hi. Um, I'm in the LLB program. I've taken a few courses relating more generally to international law. More specifically, I took like one on children's rights under international
Okay.
law, nothing regarding refugees, which is why I'm taking this course.
Okay, fantastic. Welcome. Chen Yishai? Oh, Chen, probably.
Yeah, yeah. Hello. So I don't have any like specific background about this subject. I'm taking
Mhm.
international law, and that's it. But it sounds interesting, so this is why I'm here.
Excellent. Welcome. Efrat?
Hi, my name is Efrat Shnai. Nice to meet you. I'm in my second year of my master's in law, and
Okay,
I'm a
great.
lawyer. Yeah, I'm a lawyer at the Ministry of Justice. I've been here for
Okay,
about
fantastic.
yeah, for about 5, 6 years in the Office of the Deputy Attorney General for International Law. So I'm no
Okay.
stranger to international law. I don't personally do refugee law, but we do the subject in the department, so I have a bit of a familiarity with it.
That's fantastic. Yeah, I mean, over the years, I've taught this for over a decade, and I've had various people from different ministries, and that's always great to have. So thank you, and great to have you here. Eviatar.
Uh, well, nice to be here. I'm in my third year, graduate, fourth year actually. A graduate,
Okay.
combining law and philosophy, and I don't have any knowledge of specific courses of international law, refugees law, but I'm very interested in the subject, following it in the USA, and I also live in South Tel Aviv, so I'm very familiar
Right.
with refugees hand to hand.
Fantastic. Yeah. Well, as we said, we'll obviously get to that very specific subject next week. So great to have you. Gil Alev.
Hi, I'm Gil. I'm in the military advocate general, and I do have some background in international law. This is not my main subject of expertise, and but it sounds very interesting. Uh, I remember it a little bit from my undergrad years, so.
Fantastic. Great. Well, as those of you who are eagle-eyed would have noticed, I was at the MAG um, some years ago, quite a number. So welcome. Itamar?
Hi. Hi, my name is Itamar. I'm in my undergrad at Hebrew U. Last year I studied international law. I'm not particularly familiar with refugee law, but I was in the
Mhm.
Jessup competition, and
Oh,
this year
okay.
I'm in the editorial board of the Israel Law Review.
Oh, fantastic. Yeah. And again, a journal I'm intimately familiar with, so welcome. Jessica.
Hi, I'm Jessica. I'm doing my undergrad in law and a master's in business administration. I have a little bit of experience. Just I took the basic introductory international law course, and also last
Right.
semester I studied at CTLS in London, which is the Center for
Right.
Transnational Legal Studies.
Mm,
Focused a bit more on like financial international law, but I do have
right.
a bit more of an understanding of international law in general.
That's great. Yeah. Also know some people at CTLS, so that's great. Moran,
Hi,
you with
I'm
us? Yeah.
Moran. I'm in my LLB program. I don't have any similar courses in international law, but I was very interested in the refugee, and that's it.
Excellent. Welcome.
Thank you.
We've got two Noahs, so Noah Cohen first.
Hi, I'm Noah Cohen. I'm in the LLB program, and I also don't have a background in international law or refugees, but that's why I took the course, so it sounded very interesting to me.
Excellent. That's great. Thank you. Noah Posen. I know you can't turn on the camera, so yeah, just unmute yourself if you can. If you can't, then you can introduce yourself in the chat as well. That's fine. Probably wait for that to happen. Later, just in the interest of time, we'll pass on to Noga.
Hi, I'm Noga. I'm on my LLB also. And I have a little bit of experience with volunteering with the um, refugees in the Jack organization in Jerusalem.
Okay.
So it was interesting.
Fantastic. And it will be interesting, like as I say, next week as well to kind of analyze different structures that exist in different places in the country in relation to support for asylum seekers and refugees. And then finally on my screen, I think, and unless I've missed anyone, thanks Noah for introducing yourself in the chat and welcome. Liana Kaplan, I think is the last person. My screen.
Hi,
Yeah.
sorry. Apologize, I'm driving.
No worries.
Unfortunately. I hope you can hear me well.
We can, yeah.
I'm also in the LLB program. I'm combining law with Middle East studies. I don't have a background in international law, just a lot of interest in this course, especially with the
Great.
Syrian refugees in the past 10 years.
Fantastic. Okay, great. So I think I've not missed anyone. If I have, then you can please kind of just unmute yourself and kind of shout out. And I think with that in mind, we can get started. As I say, I think the other kind of maybe general housekeeping point I'll make is we'll have like a pretty substantive break, as it were, in somewhere in the middle. Again, we're not going to be very rigid about it, but broadly speaking, we've got like a 3.5 hour time slot. So broadly speaking, midway through that. And I'll try and also kind of do 2 to 5 minutes kind of comfort break kind of in between the two so within rather the two big chunks, so that we don't run and just sit in front of a screen for an hour and a half without any break. So we'll try and find a suitable time for that. Of course, if you have to side, I understand that this is different in some sense than being in a physical class. So if you have to, I don't know, answer the door, there's a phone call or something like that, you have to turn off your screen, then that's of course fine as long as you generally are here, as I say, because I have unfond memories of some periods in COVID where I was teaching mostly dark black screens and that wasn't much fun. So I appreciate some people at some points can't do it, but overall, I'm grateful to the vast majority of you are able to be present, and that's great. Okay, enough with introductions. I think we'll get started. So, what I'll try and do is I'll try and share my screen. As I said, I will share the PowerPoint after each seminar, so that we can kind of you can follow through as I go. Um, Let me know if you can't see it. I think it should now be visible. I will also put the full screen on. Um, yeah, I think you should be able to see this in full. And I still can see you on the side screen. So what I suggest generally we do is if you do have a question or point, I mean, I'll also pause at different times to see if you have questions or to ask for your contributions. But I'm very happy to be interrupted. It's not as I say, it's not meant to be a lecture. It's meant to be a discursive seminar, and I'm very keen to hear your thoughts on different things and to clarify. And given to say some of you have international backgrounds, but many of you don't, I'll try and take this into account as I explain. But I may be glossing over terminology that you don't know, and I kind of lazily assume you do. So stop me. So you can either use the raise hand function. That will be the easiest because I'll just see it. But you can also just unmute yourself. Just feel free to do that. And just interrupt me. Right.
We still don't see the screen is not the full
Can,
screen.
can you not see the
The
full
the
screen?
PowerPoint.
Oh, right. Okay. Can you see something though? Can you see the I don't know why it's not showing the full screen then. Is it showing?
It's
Okay,
showing the presentation, but not the
it's
full
showing
screen.
okay, and that still the case? Let me see what happens now. What about now? It's still the case.
Perfect. No, now
Oh,
previously was
now,
better.
now
Now we see the next slide too. So maybe
yeah,
that's
no,
the
that
settings.
but that's okay. I'm not but you can't right, but you can but there's a main screen that you can see. Okay, that's great. Okay, so let's talk about the module then. So what I want to do in this module, and I mean, a big disclaimer here is that it may sound like a two-credit module or course on refugee law, that refugee law is quite a niche issue and, within the wider scheme of international law, and it may sound to the kind of to the uninitiated that's actually quite a lot of time. And the reality is it's not. Refugee law is a relatively new area within international law. So we'll come to discuss some of the history, but the main instrument that this course is going to be discussing is the Refugee Convention from 1951. So just about to celebrate, in fact, in July, its 75th anniversary. So in relative terms, compared to, you know, other areas of law, like some people are becoming more intimately familiar with, like the law of the sea, given recent events, and certainly international humanitarian law, which dates more than or roughly a century back, and of course other areas around immunity and jurisdiction, etc. This is relatively new. At the same time, it has a vast body of jurisprudence, given the nature of the Refugee Convention, something that we will come to a bit later as a self-applied or country by country applied instrument. You've got jurisprudence from different countries applying the same instrument, the Refugee Convention, alongside some international supranational bodies like the Court of Justice, the European Union. And you've got many different dimensions to refugee protection, very different and difficult questions around interpretation and development, about terminology, and also regional instruments, which I will uncover a little bit in this seminar, each of which has its own body of jurisprudence. So this is all to say that whatever we're going to be discussing is ultimately and inevitably selective. It's skewed towards things that I find A, relevant, B, interesting, C, ones that I have something meaningful to say about. Other people might teach this type of course differently, and that's fine. I will point to various books and textbooks as we go along. You also will see on the syllabus there are some quite significant bodies where you can venture into other niche areas within refugee law if they take your interest, and I haven't discussed them in full or at all. The Oxford Handbook on International Refugee Law, for instance, that I contributed a chapter alone and then a joint chapter to a few years ago, has 68 chapters, each on a different topic or a different area within refugee law. So it really is a vast body. And so I can't do justice to all of it. I'd rather go relatively deep in a smaller number of topics rather than attempt a very wide range kind of expose that doesn't engage beyond the surface. So that's been my approach. The second thing was implicit in what I've just articulated, which is that I use as my as you were my anchor for this course, the 1951 Refugee Convention, which means the course is ultimately grounded in doctrine, right? It is doctrinal. From a methodological perspective, I'm going to be critical in various instances of interpretations, certainly going to be very critical of state practice, where I think it diverges from what refugee law requires. But I'm not in the business, at least not in this course, of challenging the whole regime, having some attempt at deconstructing the need for the regime as a whole. I have respect and appreciation for people who do that sort of work. It's not mine, and actually my view is that to get to the point where you deconstruct and critique, you actually need to know what the body of law is. That's always been my philosophy in law. I know not everybody agrees, but that's I thought I would lay this out clearly at the start in case you're used to other things or you disagree with that, which is, as I say, entirely fair. So with that in mind, I want to explain the specific elements that the module or the course will cover. So I'm going to start, or we're going to start today by discussing the global refugee protection framework. And in order to do that, we want to initially have a bit of a health check as to where refugees are in the world. Where do they come from? Where do they end up? What is the gap which exists between the perception, often in discourses, not least in what some of us called global north countries, in which Israel is included, in fact, given its economic and other statuses, and the reality of numbers. And what are the drivers of the people who have been displaced to other countries? So that will be a starting point and a good segue, I think, to then discussing the origins of the Refugee Convention. So what prompted it, what preceded it, what it intends to do, what it wanted perhaps to do, but has not succeeded in. So there's a degree already of kind of expectation management around what this treaty does, as we start. And then I want to, before delving into the Refugee Convention definition itself, I want to discuss how the Refugee Convention compares and contrasts with regional instruments in three areas of the world. And as I say, each of those can and deserves its own module because it has its own jurisprudence, etc. But for our purposes, the point I want to emphasize is the definition of a refugee or of a person who is in need of international protection in Africa, in the Americas, and in the European Union. And to show ultimately when we get then to discuss the refugee definition itself and how it gets interpreted and what are some of the key interpretive debates and challenges, to see how it sits, how, as you were, the global system, which I would call the floor of refugee protection, so the base layer of refugee protection globally, sits alongside perhaps higher or more expansive forms of protection that exist regionally. And what that tells us, what that story tells us, perhaps about maybe also the limits of international frameworks, right, and what they can aspire to or what they can achieve. Um, so having done that, we will go into some of those specific areas of refugee definition debates. And as I said, it's very likely some of that stuff will end up happening tomorrow rather than today, depending on how we do with time. Then the second seminar will deal with what is the main driver for refugee movement globally across borders, and that is displacement from conflict, right? So people in the context of either, I know most of you will not have studied international humanitarian law, but there is a distinction between conflicts between states, say Russia, Ukraine, and conflicts that are within states, although they sometimes spill over more regionally, say like Sudan or the DRC, or in certain periods Afghanistan, and at least initially Syria. So conflicts not of an international character. Both types of these conflicts generate displacement, tragically. In the responses to these types of displacement as a matter of international refugee law may differ. And that's part of the discussion we're going to have around how the Refugee Convention deals with displacement from conflict. And we're going to also look at a very specific regime that exists in the European Union and has been only activated once. And that is in relation to people who were and remain displaced from Ukraine as a result of the full-scale Russian invasion of Ukraine in 2022. And that's a temporary protection directive under EU law that gives people status that is different from, but is intended to have a similar function as refugee protection. And we'll try and understand the difference. So why did the EU do this? Why did it not do it in other cases like Syria and elsewhere? And what does that tell us more generally about how compatible refugee law is with situations of displacement from conflict? So that's the second kind of big theme that the module is covering. The third big theme, and perhaps the most uh, I'll choose my word carefully, disheartening or um, you know, reality check-y type challenge for the practice of refugee protection um, are different state mechanisms in order to avoid having responsibility for refugees. And so this seminar really focuses on what happens when states, or how do states try to not have someone become their responsibility as a refugee. Um, the origins of the challenge for states being the principle they sign up to, which is the principle of non-refoulement, which is a term in French, but essentially translates into non-pushback or non-returns of individuals to um, territories where their life or freedom would be at risk. That is a core, perhaps the core principle of refugee law. And it's a principle that engages the state when the state has jurisdiction over an individual. And the question when the state has jurisdiction and how it then exercises that jurisdiction, whether it can nevertheless find ways for other states to take responsibility over an individual, even if they can't return them to their country of origin because of the non-refoulement principle. So practices that we call in the jargon externalization, so trying to externalize your responsibility, and the corollary of that externalization practice being the notion of containment. So states, say, think Libya, having its coast guard prevent boats from leaving Libya towards the European Union, having these containment practices by certain countries, usually transit countries, usually countries facing global north countries in the European Union, in North America, and elsewhere. So this whole idea, or this whole question of how do you access protection, assuming a state, once you are within its jurisdiction, has protection responsibilities towards you, is really at the center of refugee law, and to some extent, a more disillusioned way of thinking about refugee law would be to start from there. But I choose not to do that because I still want to think that the exception hasn't become the rule when it comes to refugee protection. But be aware that that really is a genuine, a continuing, and a serious challenge to the application of refugee law. So that will be, as you were, our third theme. Then our fourth theme, we'll talk about two categories of people who are not receiving refugee protection under the refugee definition as a formal mechanism that exists within the refugee regime, so within the 1951 Convention. The first are people we can broadly characterize as people who are undeserving or deemed to be undeserving of protection. Those are people who are excluded from refugee status under Article 1F of the Refugee Convention. People, for instance, who have committed crimes against humanity or war crimes, or committed serious non-political crimes, or and we will go through the different components. And the second kind of group, which is perhaps closer to home, and perhaps one where I would gently say there's a great deal of confusion and misrepresentation, is that of what the kind of legal regimes in international law called Palestine refugees, so people who are receiving protection or assistance from the United Nations Relief and Work Agency for Palestine refugees in the Near East, which is the full name for UNRWA. And that group falls into a specific provision of the Refugee Convention, Article 1D. And I joined those, there's a debate in the literature, but I joined those who consider this provision not to be an exclusion clause, but to be what we call a contingent inclusion clause. So a provision where under certain circumstances people are excluded, but it also creates the circumstances for people to be included, to be welcomed, as you were, back into to the global refugee definition and regime. And it's precisely this challenge, the fact that in many instances, Palestine refugees can become, as you were, ordinary convention refugees, that explains various state practices, including, I would suggest, and you will see that I'm not sure I've updated the syllabus because it really is fresh off the press, but I've just had an article a couple of weeks ago published in the International Comparative Law Quarterly that uses the question of Palestinians from Gaza not being able to leave Gaza, including to neighboring countries such as Egypt, has to be seen within the context partly of what the ramifications would be legally of people leaving Gaza in the circumstances of the last few years and going to a country which is a convention signatory. What would be the ramifications for them in terms of their eligibility to be ordinary convention refugees, with all of the ramifications that that has? So that I hope will be an interesting and perhaps quite thought-provoking discussions that we can have in that particular seminar. The fifth, and where I will hope to end this week, is seminar talks about, in a way, the circumstances of those who get refugee protection in a convention signatory, right? So let's imagine somebody, a woman from Afghanistan, having managed to, in various ways, evade the different externalization and other practices, made it to Germany, got refugee status in Germany. What rights does she have in Germany under the convention? What is the status of her refugee condition, right? Is it permanent? Is it fixed term? Is it, I would argue, indefinite, right? Essentially, neither permanent nor fixed term, right? Is it the sort of status that you hold until something happens and you don't know whether that something ends up happening or not? And that construction or that framework around this is kind of encapsulated in the cessation clauses of the Refugee Convention. This is Article 1C of the Convention, which lists a closed list of circumstances under which Refugee Convention status will come to an end. But only in those circumstances does it come to an end. And that lends itself to people being potentially holding refugee status for a very lengthy period of time, because that is correlated with the fact that the Refugee Convention does not require, even though it does strongly encourage states to naturalize refugees, right, to give them citizenship, which would then end the refugee status. And so we will talk a lot about in that seminar about that political limbo that refugees find themselves in their state of asylum. So in the fortuitous circumstances where somebody managed to get protection in a state that is refugee protective, but nevertheless remains not a citizen of that country, and as a result, without certain rights that only citizens in those countries have. I call it the refugee political predicament. That was the subject largely of my book a few years ago on voting rights of refugees. And as you'll see, I'm making a strong normative point for why refugees should be treated differently than other migrants when it comes to their political rights because of their very unique predicament compared to so-called voluntary migrants. So this is where, as I say, I hope this week will end, and then, as I've mentioned at the start, we will be joined by Shahar on Monday to discuss asylum seekers in Israel, and if time allows, depending on our discussion, we might venture a little bit into a wider discussion of some future challenges of refugee protection. So that's the game plan. Can I just see if anyone has any questions? Anything that I've said sounds puzzling or confusing or unclear. You don't know where I'm going. Not seeing any of that. So what I think will be a good time as a result is if we now do about a 5 minute kind of just comfort break, um, just to just to give us all a bit of energy to go on. And then when we resume, we will move directly to talk about today's kind of material. So you can already see on your screen the plan for today. We'll resume. I think it's now just coming to quarter past. So if we resume at 20 past, we will then, as I say, go on for probably about 45 minutes or so. So you can plan your afternoon until we have like the more substantive break. So I will see you all in about 5 minutes. Now pause the recording in the meantime. Okay, I think most people are back. Doesn't necessarily show, but yeah, I think people are coming back. And as I said, we'll try and run for about 45, 50 minutes, and then break again, kind of more substantively. So this is what I want to do today, and I've kind of introduced this more generally at the start when I went through the different components in each of the seminars. So I'll just go through this very briefly. I'll talk about the contemporary context for refugees, about the 51 Convention itself, its preamble, which I think is important because it tells you a story of why this convention was drafted at the time it was drafted. That's always, in my view, something that you need to investigate when you look at I'd argue domestic legislation as well, but absolutely international documents. They don't arrive at the time they arrive by mistake. There's always some context, and in this instance, the context is pretty obvious, and its effects on the draft are evident. So we'll talk about that, about the tenets of the convention and its logical structure, and then talk about something that I always find as core and substantive and significant to the refugee regime as it is difficult for states and often for others as well to wrap their hands around, which is that the refugee status as a concept is a declaratory status. It's not constitutive. So it's a status you receive because you meet the definition, and it's not made by virtue of being recognized as a refugee. This may now not make sense, but it will hopefully when I explain this a bit later. So we'll talk about that, and then about the so-called inclusion clause, right? So you saw on the previous slide, I was surveying the different kind of categories of people who are not enjoying refugee protection, right? The exclusion clause, the contingent inclusion clause, when refugee status comes to an end. But obviously, to get to those points, we first need to conceive of who does get refugee status and on what basis. And that is the core refugee definition in Article 1A2 of the Convention. Why 1A2? Because there is a 1A1, and the 1A1 pertains to people who are so-called statutory refugees, virtually none of them would be alive today, but those at the time of the drafting were very relevant. Those were people who got refugee status under uh, bespoke, specific regimes that existed prior to the Refugee Convention, prior to 1951, including Jewish refugees, for instance, from Germany and Austria and others. So that's why the refugee definition is actually in a subsection of that wider provision. So we'll talk about the inclusion clause, and as I said, compare and contrast that with regional definitions in Africa, in the Americas, and in the European Union. And then we'll delve into some specific core interpretive questions of the refugee definition. What is a well-founded fear of persecution? What does that mean as a matter of law? Can non-state actors be agents of persecution? The the spoiler is the answer is, well, at least today the answer is yes. And it wasn't always the way the refugee definition was interpreted. So we'll try and unpack why there's been this development in understanding of what refugee law is intended to protect. And we'll talk about perhaps the most challenging but also promising element of the refugee definition, which is the ground for protection of somebody being persecuted or having a well-founded fear of persecution because of their membership of a particular social group, right? So this notion of a particular social group, what does that mean? Who can this refer to? Who can this refer to in 2026 as opposed to in distinction from 1951 when this was drafted? And how does that sit comfortably or not with the very big gaps in understanding of needs for protection of, for instance, sexual minorities, for people on the grounds of their gender, um, back in 1951 and today, and the divergence that exists even within countries that are all signed up to this very same document, right? So that will be, I think, an interesting angle to explore. We'll then kind of talk about two specific kind of effects of the refugee regime being a regime that people like Jim Hathaway call a surrogate protection regime, right? So it's a protection that kicks in when the states that was supposed to be protecting you, ordinarily your state of nationality, although refugee convention does apply sometimes to people who are stateless, so that would be their state of ordinary residence, right? When So surrogate protection kicks in when that state fails, right? Ultimately, that's a very simplistic way to frame this. And obviously, we talk about the refugee definition. We will unpack this much more substantively, but that to me is at the heart of it. And then somebody else has to step in essentially to perform a surrogate function. And the reason that's important is because the refugee regime essentially says, why did you come to me first and not go somewhere else, which is a more natural surrogate? And that's this notion of multiple nationalities, the idea that somebody might have another country that they should turn to first before you come to a country of asylum, of refuge with which they have no connection, right? So that's that will be part of our discussion. And then the other element of refugee protection, which again is, I think, counterintuitive to a lot of the public discourse around refugees. A lot of the public discourse around refugees assumes refugee protection is some sort of a redress or prize or a compensation or a consolation for something that has already happened to you. Whereas actually refugee protection is forward-looking. So the notion of refugee protection is focused on what will happen to this person if that person were to be returned to their country. What happened to them in the past can be um, indicative, right? Often it's a strong indication, but that's not the legal question. The legal question is a forward-looking question. Is if I send this person back to Syria or to Sudan or to Gaza or to Afghanistan or to Venezuela or what have you, what will happen to that person? And the reason that's important, right? The reason the fact that refugee protection is forward-looking is significant is because of this idea that somebody can become a refugee even when they weren't a refugee in the first instance, having entered the country. So I often, and we'll talk about this in the context of Refugees Who Plus, but imagine somebody was a student from Syria coming to study in the United States in 2009, a year and a bit before the Arab Spring, so called, right? And at that point, imagine this is somebody who had no political affiliations or qualms with the regime, and they came on a student visa, right? But their studies are coming to an end in 2012, and at that point, there's a raging civil war, and they can't go back. And there's a question: you haven't entered as a refugee. How can you now be a refugee? Well, the notion is that because refugee status is forward-looking, at the point in which that application or that decision is made, they might very well be refugees, and that's the concept of refugees sur place, so refugees in place or on place in French. Um, so they have become refugees, having not initially been refugees, right? So we'll try and discuss this, and then the final point, which in a way is implicit in all of the discussion earlier, is the notion of diffusion challenges, right? So the notion that the refugee definition is self-applying, right? In the sense that countries have signed up to the refugee regime, but they haven't created, and this is something we'll come to when we discuss the preamble to the convention, they haven't created any global mechanism. I emphasize global as opposed to regional, any global mechanism to enforce this convention, right? Enforce in the sense of having legally binding judicial determinations, right? That say you a decision maker in Canada, or you a decision maker in South Africa, or you a decision maker in Turkey, or you a decision maker in Israel have made an error in relation to this person. There is an international authority that would correct that error and would grant that person or deny that person, refugee protection. There is no such body that has enforcement power and decisive, authoritative decision making. There is a body which we will become familiar with called the UNHCR, the United Nations High Commissioner for Refugees, which has certain important roles under the convention, but they're not enforcement and they're not authoritative. And that leads inevitably, because you've got, as we will see a bit later, well over 100 countries who are signatories to this convention. They all have their individual legal systems. They all have their procedures. They all have their standards. And even though they all sign up to the same treaty, the diffusion challenges are almost as self-evident as they are troubling, right? And they're troubling for the obvious reason that you have someone fleeing objectively a certain set of circumstances. Should it really be the case that the question whether they'll be recognized as a refugee depends where they end up, given that there's one international instrument to which these different countries have signed up to. That's often referred to as an asylum lottery. Again, it may not be unique only to refugee law, and certainly within international law, it may not be a unique feature, but the ramifications, given we're talking about vulnerable individuals, are severe, right, and are dire. And so the question, can this be remedied in any way, is something we might come to as we discuss. So that's what I want to do, as I say, today, and quite likely to some extent tomorrow. Any clarifications or questions on this? Realize I'm speaking a lot, so just want to see that everybody's happy. Okay, so I'm now gonna start inviting you to contribute. So by all means, feel you're very much invited to do so. And the first kind of point that I want to uncover is this notion of displacement in numbers, right? So I want to talk about where people are displaced. But before we talk about where people are displaced, we want to talk about how many people are displaced, right? So um, I hope you can see this on your screens. I know the kind of the print is a bit small, but can anyone tell me what's the most striking feature of this slide, right? Which is the group that's kind of in a way um, is the most prominent on this slide, and what is that group's relations to refugee protection? And it might be an educated guess at this stage because we haven't properly studied it.
I see internally displaced people.
Right.
And if I understand correctly, those are people that are still in their country, but are suffering from having to move to another place, out of their home, out of their natural place, maybe because of war or other reasons, persecution. And it seems that these people aren't getting protected by refugee law. I mean, they're still in their place. They're still subject to persecution or other things.
Absolutely. So that's 100% correct. Thanks, Aviatar. Um, so I kind of, in a way, the reality check that where we start this module with is that the biggest group of people being displaced globally are people that fall outside the global refugee regime and all of the regional refugee regimes, right? So when we come to look at the different refugee definitions, we will see that they have tailored to the regional needs the refugee definition and ultimately made it more expansive, more protective, but they haven't increased protection beyond those who are displaced across international borders. Now, one important point, right, which corresponds to all of the other groups on the slide, is you need to have left your country of origin. You don't necessarily, in order to meet the refugee definition, need to be already in another country, right? Why is that important? It's important, for instance, if somebody is on the high seas, right? If somebody is in a boat between Libya and Italy, right? If they are in international waters, they're not in their country of origin, and they're not yet somewhere else. If they meet the refugee definition, they are refugees. They, of course, need to be recognized by somebody. They need to be taken or become somebody's responsibility. But they have managed to do that first critical step in the refugee definition, which is to leave. Right, so Vitar is absolutely right. We've got actually the biggest category, but also the one that's most rapidly rising in numbers if we compare it to earlier periods, right? And this is the result of conflicts in places like the DRC, places like Sudan, places like Afghanistan and Syria and Ukraine, where actually more people were displaced within Ukraine than outside Ukraine, even though the numbers of people displaced outside Ukraine is also very, very significant, right? So that's the category we're not going to be discussing. The next question I want to ask you is, what do you think is the difference in this slide between the category in light blue um, and the category in dark blue? So why is there a distinction between people who are refugees under UNHCR's mandate and people who are asylum seekers? Why is that a relevant distinction?
What is UNHCR again?
So the UNHCR is the United Nations High Commissioner for Refugees. So the refugee agency that exists under the refugee definition and is distinct from UNRWA, right? Which is going to be my next point, right? So why is there a distinction there between asylum seekers and refugees, or what is the distinction?
Because asylum seekers aren't recognized as refugees by anyone yet. And the status is still
Right. Okay, go on.
undecided.
But what we know about them is that they will have left their country, right? And they have applied or in some way indicated that they believe they meet the refugee definition, but as you say correctly, they haven't yet been given that status. So they're in the status of seeking to be recognized as people in need of asylum, namely refugees, as opposed to those who already have been recognized in some form or another, which is that category in light blue, right? The 20, or sorry, the 31 million refugees under UNHCR's mandate. So people who UNHCR considers to be people who meet the refugee definition in those various respective countries and have received some form of protection. That protection may or may not be fully compatible with the obligations under the convention, right? So that's the discussion we'll have in the fifth seminar, right, on refugee rights and whether those are met when, for instance, people are left in camps, people are denied the right to work, people can't organize politically, people can't travel, right? So there are all sorts of things that states may breach in relation to refugee rights, but those would still be people who qualify as refugees, right? So those are those two additional categories. Then we come to Palestine refugees, right? So those are people who the United Nations Relief and Work Agency deems to be eligible for its protection or assistance, right? So they live, and we'll talk about this in the relevant seminar. They live in UNRWA area of operations, which are Gaza, the West Bank, including East Jerusalem, Jordan, Syria, and Lebanon, right? So they have to be in one of those areas, and they have to be people who UNRWA considers to meet its definition. I don't want to go into the details of that definition now because that will be the subject of a separate session, as I've said. And then the final category. Sorry, go ahead.
Sorry, maybe I'm moving ahead. I just haven't the idea of people who seek who have their some legal rights taken away, like the freedom to of political expression or working whatever they want. There are many countries, arguably maybe most of the people in the world, who are living in standards that are considered by many modern liberal people are they don't get the right at all. So in this way, most of the people can be recognized as refugees. I mean, how do you decipher exactly?
So as you and I think you've acknowledged at the start of your question that is something we're about to come to, right? Either today, as I say, or tomorrow. That is precisely the question of the so-called nexus in the refugee definition, or the connection between the well-foundedness of your fear of persecution and a convention ground. So if you've got a state where virtually everyone is denied, say, certain political rights, say Syria under the Assad regime, that ground on its own, so coming to another country and saying, I do not have a right to vote in my country, would not be a ground for refugee protection because you're not treated differently than other people in your own country on one of the convention grounds, right? So there needs to be a degree of differentiation in the treatment that is relevant to, linked to one of these categories. So it has to be related, and I say I don't want to fully preempt this, but it has to be related to your race, to your nationality, to your religion, to your political opinion, or to you being a member of a particular social group, right? And that's the heart of the refugee definition. That is why the refugee definition would not tomorrow morning welcome into an ordinary multi-party democracy, by definition, all the people from a country that doesn't have free and fair elections, right? So that in itself would not be a basis, and that was clear from the refugee drafting process, right? That isn't the purpose, right? It doesn't mean that there cannot be circumstances where large parts of a country's population, if they were to be displaced, would meet the refugee definition, right? So if you've got a large minority, for instance, a large ethnic minority that is being persecuted by a majority, any member of that large minority in certain circumstances would be eligible if they could only make it to a place where they could get protection, right? So there is a tension there. So what
Yeah,
you're
but
highlighting, sorry, go ahead.
yeah, I think the tension is even very strong because, I mean, in some countries, the women are by definition aren't given the same
Mm,
political rights and are prosecuted in many ways
sure,
compared to men. So, and they're not even minority. So, but they are
sure.
prosecuted. So, in this way, does every woman from Afghanistan or Iran or whatever it can be can ask for an asylum?
Well, there is I mean, as I say, I think that's a discussion I want us to have like more fully. But I mean, my own view is that under the Taliban regime, if um, women manage to flee the Taliban, then it's very difficult to see how they're not eligible for refugee protection, given the level of persecution. I think one needs to distinguish, and again, this is what the refugee definition is trying to do, and the refugee regime is trying to do, between what I would say mere differential treatment or discrimination. And a standard or threshold of persecution, but so it's not necessarily, or I think um, there is an argument to say that simply having some forms of discrimination may not be sufficient, but the sort of level of repression that exists at the moment, terribly, towards women in Afghanistan. Yeah, I mean, I think it's a real challenge. Of course, the difficulty is that it's not possible for them to get somewhere else where they would be recognized as refugees, right? And perhaps that's part of the tension, right? It's precisely because of being aware in certain, say, Western countries or countries in the global north that if they did make it possible for people, for women of Afghanistan to come and claim asylum, there would be very many of them would be eligible. That doesn't happen, right? So that's the sort of tension I want to tease out and say the module or this course isn't necessarily giving you what would be the best policy prescription. It's presenting the the consequence of the legal framework, right? The consequence of the legal framework is, I think, as you rightly indicate, that there are countries in the world where large parts of the population, if they were to flee them, would be eligible for protection somewhere else. I think that is the case. I think that probably is the case. I don't want to go through the whole list of places where minorities are persecuted, but there are certain minorities in China where that will be the case for. There's certainly minorities in Russia where that will be the case for. There, talked about Iran and other countries. Yes, I mean, I think that is true. And the difficulty with refugee law is that they need to become someone else's responsibility, and for that, and this relates to the earlier discussion, they need to leave their country of origin and head somewhere else, right? So that's where the tension lies. So we'll return to this tension in many different ways. So we haven't exhausted this discussion, and it's good that you've prompted it. So, um, so the last group that you see on your slide are defined as other people in need of international protection. I always, I use this slide because it's a very helpful visual slide, and I didn't have or I don't have the energy or skills to produce my own, but and it is an official UNHCR slide. Um, I don't love this category because it seems to kind of blur the boundaries in a way, or maybe that's its purpose to some extent between refugees and just other migrants. But this is a specific reference to people fleeing Venezuela under the Maduro regime to neighboring countries primarily. And that's why you see zero people in that category up to 2017, and then an increasing number, kind of a gradual increase up to 2024. I don't actually think there has been a massive return, although I stand to be corrected after as you were, the snatching of Maduro by the US, and the kind of installing of a different leader, right? I don't think that has necessarily led many people from Venezuela to originally from Venezuela to return, but some may have from neighboring countries. But those are people who tended to get other forms of protection that are not refugee status, partly because it wasn't clear that they would meet the refugee definition if um, they did apply, partly because of the places to which they were displaced, which were primarily neighboring countries, where there were other regimes in place that were perhaps more accommodating or more suitable for them. So UNHCR treats them almost as quasi-refugees on this slide, right? That's why I'm not very happy with this framing. But that's the group that the category in red is referring to. So that's where we are. So I mean, I think one question that I want to kind of probe with you before we move to where people are displaced from, just the next point I want to discuss, is what do you think about the number as such? So think about, let's discount for the purposes of our the effect on the world, as you were, on other countries. Let's discount the people who are internally displaced, right? So if we set them to one side, and if we set Palestine refugees also to one side, given they have very specific locations and a specific regime, we end up with ultimately something in the order of 45 million people, right? So that's the combination of refugees under mandate, asylum seekers, and Venezuelans, right? So 45 million people. Um, when one uses that sort of figure, what's your reaction to um, that in the context, in the global context? What do you think that tells us about the global refugee problem or challenge, or what's your take on it? Is that a high number? Is that a low number? Is that a manageable number? What are the challenges that arise from it?
Well, it seems like the number is growing throughout the years. Even if it could be a manageable number, it seems like an issue that's the trajectory seems to be that it's going higher. Maybe, I don't know.
Well, I think that's true. I mean, this graph is a little bit, I wouldn't say misleading is too strong, but it's partial, right? In the sense that uh, if you started the graph from 2000, you would see that actually not internally displaced persons, but actually people displaced across borders, in the early 2000s, the numbers were equally large, right? And if you think about Iraq, you think about Afghanistan, You think even in the 90s, you think about the Balkans. So it's not that there's unidirectional increase, but overall, certainly in the last decades, there's been an increase, and we will talk about the causes for this. So that's one thing that we can, in a way, deduce from this figure. But what can we also say about so thinking about the world as a space, right? Think about the kind of Artemis mission that just returned and kind of saw us. If you zoom out, the way they did when they were kind of orbiting the Earth, you zoom out, you think there's 8 billion people on this planet, right? And 45 million of them are displaced across borders in circumstances that meet the refugee definition. What does that kind of ratio tell you about the manageability of the refugee issue? I mean, it's a bit of a leading question because I'm leading you to kind of the later discussion of where refugees are and where they come from. So
it is manageable.
Sorry, go ahead.
Yeah. Will? Yeah, go ahead.
I was just gonna say I think it's manageable, but it depends like how dispersed these refugees are. Because if it's 45 million people from one little pocket of the world, that's one story. But the number itself, I think, is pretty manageable because that's the size of a lot of countries, and we're 190 something countries. So,
right,
in my opinion, at least.
Great, thank you, Will. And I think you went there when we did the introduction at the start. So do you want to just say quickly what brings you to this course and which program you're on?
Yeah, I'm in the MA of Law and Human Rights. It's a one-year
Right.
program, and I think this is, I can't remember if it's obligatory or if it's
Mhm.
an option at this point. But either way, I'm fascinated in the topic. So yeah, out of just interest, I guess, is what brings me to the course. It's too bad that we can't be in person, but
Yeah,
I'm
well,
excited. Yeah.
absolutely. Well, welcome. Thanks,
I'm
Will.
kind of a refugee myself right now because I'm not in Israel. So
Right. Where are
I'm not a
you
refugee, but
yeah,
I'm
yeah.
originally from Canada,
Originally
actually.
from Canada.
Yeah.
Okay, I see.
Yeah.
Sure. Sure. Okay, fantastic. Thanks, Will. Great. So, Evyatar, you were going to say something as well, I think.
I want to say I do agree with Will. I'll say does mean that there do need to be cooperation between different nations and all in good faith, which I fear doesn't necessarily happen today, especially with different laws of different countries. But I do suspect, like I sort of hinted earlier, that there is a level of manipulation maybe on the numbers and the way that we keep it manageable, because I think there are more than 45 million people who need uh, help and are in distress and can be eligible for refugee laws by some standards that other refugees are accepted, and even maybe more than the 73.5 million that are internally displaced. There could be even more, unfortunately, because the world still have so many people that are under very, very harsh regimes and suffering a lot, or eligible to suffer if they'll do anything that we consider to be completely normal and okay.
Sure. So I think both will. Thank you. Anyone else wants to come in at this stage? I'll obviously, everybody's welcome to contribute, and there's no correct answer to this question, right? But because it is a normative question ultimately. Will, did you want to come in again or no?
Yeah, I think I just wanted to add as well, it depends on what countries, what refugees are being ushered to, because when I think about the
Right.
Ukraine example, they were primarily absorbed by Europe, which is very compatible, both geographically and I guess culturally and values. And to my best knowledge, I don't think there's been many issues absorbing millions upon millions of refugees into Europe. But I mean, if we take other examples, maybe there's been more challenges. So I think it depends on where exactly they're going and what type of I don't know, value system, culture, infrastructure set up to begin with?
Right, so that's a really important question, or point rather. I mean, we'll come back to the integration point as well, and we'll talk tomorrow about I think about Ukraine and more specifically. But you are absolutely right, and we'll come to Ukraine in a slide in a few minutes. I mean, Ukraine is an unusual example of actually very large numbers of people being displaced to actually not that many countries. I mean, there are Ukrainians in almost any EU country now, but the vast majority are in relatively few countries in a short space of time in a way that ended up being very manageable to those countries. So even if we zoom in kind of in terms of numbers and we think about a disproportionate allocation of refugees, actually um, your other point, which is the contentious kind of challenge that we all have to face, right? Which is it's not just about numbers, but it's also about whether countries are genuinely wanting to absorb refugees, whether refugees are deemed quote unquote compatible, and whether they, but perhaps also whether they are, right? So that's the more difficult question, and whether that should make a difference, right? The refugee definition or convention says no, right? The Refugee Convention explicitly in Article 3 says you cannot discriminate on the basis of someone's nationality and other grounds in admission decisions. So you can't do what the so-called Trump ban did in the past and the president say people from certain countries can't be refugees, right? That's a direct breach of the Refugee Convention. But there's a deeper point, which I think, or a different, deeper challenge you're alluding to, which is the willingness of states to open the borders to large numbers of people and to certain people, but not to others. And that's something we'll have to engage with, and we will. So I'm grateful for that point. There were other points that I think both you and Aviatar made about, particularly about the distribution, right? So again, if we do this zooming out Artemis mission style kind of question, and we say we've got 8 billion people, we've got 40-ish million people who are displaced, albeit with the challenge Aviatar's made that this might be artificial because these are the people who managed to leave, right? And not the people who are in need of protection. That's about 0.5 of the world's population, right? So if this was distributed equitably, right, in a way, if everybody took in the equivalent of 0.5% of their resident population, it would in most instances be very, very much manageable, right? I think that's an objective point that most countries, if they needed to absorb 0.5% population, would, given proper infrastructure in place, that be able to do that without it undermining the state. Right. I think maybe some people in the call disagree, but I mean, I'll put forward that will be my position. But that, of course, is not the reality, right? So the reality is not that the 40-something million people are distributed equally across the world. And it's also not the case that you've got 0.5% of each country being displaced, right? So it's not the case that a tiny proportion of all countries find or need protection and find it somewhere else, whereas the vast majority of the population stays put and is not subject to any challenges. The reality is that very few countries produce large numbers of refugees, and very few other countries absorb most of those refugees, right? So that is the practical framework in which we operate, and so let's look at those figures, right? So 52%, this is a few years ago, right? A couple of years ago. This data, I think, end of 24, right? So because they haven't published for some reason an equivalent slide, so I'm using this advisedly. So these figures are from end of 24. 52% of that figure of the UNHCR's kind of people under UNHCR mandate, quote unquote. So of those 31 million people originate from three countries, from Syria, from Afghanistan, and from Ukraine. all happen to be countries that were in or are still in a form of conflict, right? Where do these people end up? Well, the majority of them end up in 5 countries, right? They end up in Iran, interestingly, right? So many of the people from Afghanistan have ended up in Iran, very large numbers, in fact, because it's a neighboring country and because it had porous borders and because it didn't expel them, right? So all of those reasons combined. There have been some tensions in recent years, actually, around Afghanis in Iran and around people from Pakistan in Iran. So some of these figures in Iran include Pakistanis. Some of them include people from Syria even and from Iraq, interestingly, right? So Iran is there. Turkey is high up there, and the figure in Turkey probably now surpasses Iran. Primarily people displaced to Turkey from neighboring countries, from Syria, from Iraq, but also people making the journey all the way from places from like Afghanistan and ending up in Turkey, um, perhaps in some instances with a wish that is unfulfilled to continue their journey further and to get to Europe, right? Ultimately, and to seek protection there. And we'll come when we talk about externalization. We'll come to one of the most um, profound examples of externalization in recent history, which was the agreement, so-called, between the European Union and Turkey in 2016 that essentially quelled or stopped the boats crossing from Turkey into Greece. And why did it stop the boats? Because the European Union did not want these boats to cross, and Turkey was being recorded. So I'll use a less aggressive term than I would otherwise use, but Turkey has been compensated financially for its efforts to that effect of stopping people from crossing, and also for hosting people, one should say, legitimately. And so Turkey is a big refugee host countries. Germany is the one global north country that is on this list, and that's a combination of 2 populations in Germany. One is Ukrainians. About 1 million or so of this figure are Ukrainians who have arrived in Germany. The other is the big immigration or refugee wave of the summer of 2015-16, when Germany was the only European Union country that was genuinely welcoming to Syrians and to some extent to Afghanis. The then German Chancellor Angela Merkel famously said, "Wir schaffen das," right? We can do it. Was a very controversial policy within the European Union, and we'll come to some of these discussions around responsibility sharing, which was attempted at and happened to a limited extent, but certainly not to a serious extent. So that's Germany for you. You go further down the list in the second tier, as you were, between 10, 11, and 20, you will find other European countries, but sorry, other global north countries rather than European countries like Canada. But generally speaking, the countries further down remain countries in the global south. So Colombia, the main host countries for Venezuelans, Pakistan hosting people from Afghanistan primarily, but not just. And then if we went further back, we would find places like Uganda, which is a big African refugee host country for neighboring countries. Kenya is also there, right? So the first thing to kind of note about this division is that most refugees globally, right, about 75%, give or take, end up in neighboring countries. That is the reality of the ability to seek protection. Those tend to be other countries in the global south. The unusual case, as Will has pointed out earlier in his intervention, is Ukraine, right? Because Ukraine happens to be it's an unusual refugee-producing country in the fact that it borders, at least from one side, global North European Union countries. Of course, there were many Ukrainians also, or people who are Ukrainian nationals, usually ethnic Russians, who were displaced from Ukraine or have left Ukraine to Russia and to Belarus, right? So there's that other side. But most Ukrainians who left for the European Union. That's unusual, and that's part of the drive for the numbers in Germany. But generally speaking, about three-quarters of refugees are in the global south. Sorry, are in neighboring countries, and the corollary of this is that over 80% of refugees are in global south countries. So are in countries that are themselves relatively weaker economically, often have themselves challenges of stable governments or challenges in relation to whether they can offer meaningful protection. So a country like Uganda, we might come back to in relation to the Israeli agreements with Uganda and Rwanda. For instance, if you're a gay refugee from a neighboring country in Africa, you may be fleeing a civil war in a neighboring country like in South Sudan, but for you as a gay person, Uganda is very much not a welcoming or a safe place because it has one of the harshest laws on sodomy in the world at the moment. And so this idea that people may end up actually as refugees in countries which themselves are not protective of their specific characteristics is another big challenge of the the lack of proper distribution of refugees globally. So the bottom line of this analysis is that yes, 40 or 45 million people out of 8 billion may not be such a large figure, but at the same time they are very much not distributed equitably, and we'll come later on to discuss why that is the case in terms of the refugee structure. And they're not hosted, so they're not leaving equitably, and they're not hosted equitably in other countries. And so I just want to finally, before we break, talk about people fleeing Ukraine, right? And talk about this kind of map. And we see, and this is again from about a year ago, most people fled to neighboring countries. In fact, Germany is the one exception because it's seen to be a very welcoming country. It seems to also be the closest to Eastern and Central Europe that is in a better economic state with more jobs, perhaps, and more opportunities because Ukrainians were able to choose ultimately which European Union countries they want to go to, which is not the reality most refugees find themselves in. We'll talk tomorrow about the specific regime for Ukrainians. So many ended up in Germany, but still the majority ended up in neighboring countries, primarily in Poland, in Hungary, and in others. And it's a very sizable number, right? So if we think about it as a concept, right, the European Union has absorbed about five times the number of refugees from Ukraine in broadly the space of a month or two than it did in that summer of the so-called refugee crisis in 2015-16, when people were crossing from Turkey, who were primarily Syrian, Afghanis, to some extent, Iraqis, Palestinians. So five times as many people were absorbed in a shorter space of time in the European Union in a way which, as Will has indicated, has been not the source of public discontent or public discomfort or resistance, but actually as something that seemed to have gone quite easily. And I think we need to consider that contrast in mind as we proceed with the course. And and think about that tension that I think is fundamental between obligations on paper that states have and their political will to exercise those obligations in certain circumstances, and in relation to refugees coming from different places, right? And that tension is very alive and cannot be brushed off the table. It's very much here. So I think that's for me is a good point where we can pause for a longer break. So unless anyone have questions about this, I think we will maybe do say a 25-minute break, say, come back at 22 the hour. Then we'll plan another short break, another 5-minute break or something in the space of the other hour and 20 that we would run. But we would run our course to your 6 o'clock, I think, time, as is timetabled. So yeah, if there's any question, I'm happy to take it now, but otherwise, we will resume in 25 minutes. See. Okay, well, I will let other people answer that question on the WhatsApp group. I mean, I'm not sure whether you would want me in it. If somebody sets it and you choose that it's better not to have me in it, then that's fine. If you want to add me, then it's also fine. So that entirely up to you. Great. So I will pause the recording now, and we will. So I'm going to resume the recording now. Just give it another maybe 30 seconds for people to be back with us on camera. Then we can get started. So I will revert to the point where we were, which is, I think, here. Let's see. Great. So before the break, we we talked about the kind of unequal, inequitable kind of spread of refugees across the world, right? So where people end up being displaced too. But I think one important question that we want to probe before we go into the refugee definition is that, and this is ultimately, a law class, so we need to ask ourselves, are countries actually committed legally to the refugee regime, right? I talk about the 1951 global refugee regime, and you will see in the next slide a reference to a protocol from 1967, right? So the New York Protocol, significance of which I'll come to. What is the extent to which those really are benchmarks that apply the world over? So this is, I think, a very interesting kind of framing for our discussion, right? So I think the one striking feature of this map is that there are continents like the European continent, like the Americas, that are essentially all committed to the refugee regime globally. As I say, I'll come to the 51-67 convention distinction in a second. The African continent is almost nearly committed as well. So the exceptions, as a matter of law, in terms of countries saying we're not see ourselves bound by a global regime, Libya, Eritrea, so one big transit countries of refugees that is unsafe for them, which is Libya, one big refugee producing countries, actually one of the countries where, as a percentage of population, the largest numbers of people, one of the largest percentage of its population being displaced externally, even though it's a small country, which is Eritrea. And then Western Sahara, whose status is contested in international law, and so it appears on the map. But otherwise, the African continent is committed. The continent where the big gaps in international commitment to the global refugee regime is Asia. So large parts of the Middle East, with the exceptions of Israel and Yemen, for historical reasons. I think when Yemen was still a British colony, and that somehow carried over, at least initially. But significantly, countries like India, countries like Bangladesh, countries like Indonesia, countries like Thailand, right, are not signatories, and that is important, right, in terms of understanding the development of refugee law. It also affects the ability of organizations like UNHCR, for instance, to insist that those displaced to those countries are treated as refugees, right? So one distinction that I already want to draw here, and we will come back to in much greater depth rather, in the seminar on non-refoulement, is between the obligations under the convention and the extent to which countries may still be bound by a non-return or non-pushback obligation. So the non-refoulement principle, arguably, it's a contested point, but I'll make it, arguably is a principle of what's referred to in international law as a customary international law principle, which means it binds also countries that have not signed up to the international treaties. And it also exists in other non-refugee law conventions, which are more widely ratified, like the Convention Against Torture, for instance, which has nearly all countries in the world signed up to. But when it comes to specific rights that refugees have under the Refugee Convention, say the right to be issued with a convention travel document that allows you to cross the border as a refugee, or the right to certain social welfare and housing that the convention protects, like the ability to come to a country and claim that it's breaching those obligations towards those it is hosting as a refugee, obviously limited for an organization like UNHCR if that country hasn't committed. So UNHCR is on this kind of ongoing interesting kind of yearly drive to try and get more countries to sign up to. And there's an interesting dimension here, right? Which is a lot of the big refugee hosting countries have not committed to refugee protection. Turkey is a very interesting example, and this kind of links me or is a good segue from my perspective to talk about that 1951 convention, 1967 protocol question. And the reason it is the ordinary or the original 51 convention, which we're about to come to in terms of looking at its history, had a dateline. The dateline was that refugees are those who were displaced before the 1st of January 1951. And it allowed states, when they signed the 51 convention, to treat essentially that dateline as a cutoff point. And that's why countries like the United States at the time said, there's no point for us to sign this because we will not be receiving refugees at all because we're on the other side of the ocean. They're unlikely to come to us, and we haven't received them before the dateline. And so there was a dynamic over the period between 51 and 67 of trying to inquire whether that dateline makes sense. And obviously the issue of refugees or the existence of refugees hasn't stopped magically on the 1st of January 1951. And so in 1967, the New York Protocol extended the application of the convention beyond 1951 and made it without a cutoff date, right? So essentially, make it a continuous form of protection. That was the first important thing the protocol did. The second important thing the protocol did was to remove the other restriction in the original 1951 convention, which has rendered it justifiably, a title or an uncomplimentary title of, a European um, refugee convention rather than a global refugee convention, because the original treaty allowed countries to say that only refugees coming from Europe to their territory would be recognized under the convention, even though it had a premise and a promise of being a global framework. And the reason this now harks back or links back to my point about Turkey is that Turkey, as you see on this map, is in dark green, which means unlike Madagascar, which is notable here as a country that did not accede to the 1967 protocol, and so in Madagascar, effectively, new people won't be recognized as refugees under the convention, at least. Turkey did sign the protocol in 1967, but he then decided to make a declaration stating that it will still treat only people coming from Europe to Turkey as refugees within the meaning of the convention. Now, anyone looking at the geography of Turkey and thinking of where people get displaced to Turkey from would realize that that excludes about 99 point something percent of the people who end up in Turkey from being formally recognized there as convention refugees. Now, I said before the break that Turkey is one of the big refugee hosting countries, and I stand by that statement, right? Turkey hosts people and it treats them ultimately quite reasonably within a comparative perspective, but it doesn't give them refugee status. It gives them protection under a domestic law that distinguishes and differentiates them from refugees and insists on keeping this position. And to me, that's always a really interesting example of this again, the tension between states actually providing protection and states wanting to make sure that when they do it because of a policy decision they make rather than because they're bound by international law to do so. And that's the attempt of Turkey to take that view. Now, I think if you ask me, putting on a hat of a general public international lawyer, whether that declaration Turkey made in relation to the protocol makes sense, can you make a declaration that essentially renders the protocol you've just signed inapplicable? Is that the good faith, declaration in relation to an international document? Probably not. It probably would render that declaration invalid. The reality is that this is how Turkey, in its domestic law, treats its obligations. And so the picture globally I think it's important to realize the picture or to see the picture as is before we delve into I think the benefits and the important components of the refugee convention and definition, of which there are many. So I'm not one of the people who kind of think refugee convention is insignificant or is dated or um, is unhelpful to anyone. I mean, that's simply not, in my view, true. But it is the case that there are pockets of non-compliance or non-resist or non-adherence, perhaps a better framing, in significant parts of the world. And many of the refugee producing countries are surrounded by countries who themselves are not adherent to this international framework. So I think it's important to kind of put this in context, and then that will take us now to look at what the Refugee Convention did try and has succeeded perhaps in doing. Any questions on this or comments? No. Okay, so I mentioned at the start that I want to look at the preamble to the Refugee Convention. The reason I want to look at it is because I think it's a good place to see what the drafters were writing this treaty, the background against which the writers was drafting this treaty, and also to see what they try to achieve and what they, in a way, acknowledge the limitations of in terms of being able to achieve. So the initial context, this is a treaty from 1951. The negotiations to adopt this treaty started about a year before, right? So we are several years after the Second World War, after the Holocaust, in the height of the Stalinist regime, with mass persecution and displacement and other ill treatments in the Soviet Union, with still people being displaced from the consequences of the Second World War in Europe itself. And at the same time with an new international framework, or alt neu, right? New old international framework, with the UN replacing the League of Nations, which went defunct in the 30s and then disappeared. And with an attempt of the UN to create a human rights framework, right? So there's a big debate as to whether one should see the Refugee Convention as such as a human rights treaty. It's a complicated kind of, I suppose, doctrinal question. I tend to say it is, despite the way in which rights are framed in this treaty, which is not as rights, but as state obligations in certain circumstances. But it's very clear this convention was written at an age where the international community was seeking to create a human rights framework, right? And it did so firstly as a aspirational declaration with the Universal Declaration of Human Rights in December 1948, and with the negotiations that, because of the Cold War, led to an adoption of two separate international instruments, the Covenant on Civil and Political Rights and the Covenant on Economic, Social, and Cultural Rights, because the Soviet bloc wouldn't accept civil and political rights, and the large parts of the United States and others would not want to accept socioeconomic rights as justiciable and ones that they're bound by. And so the human rights framework ended up being split, but there was an era of adopting international, or starting to adopt and develop international instruments. And it's against this background that the drafters of the convention said, well, look, we have this world where we expect countries to provide for their residents or inhabitants certain rights, and we expect that to be the case without discrimination on prohibited grounds. This is the aspiration. This is the principle in the Universal Declaration that human beings shall enjoy fundamental rights and freedoms without discrimination. And so the refugee framework can be seen, I think, as a response to a failure of states. I said this before the break as well, the failed state in relation to the protection obligation that it has towards some of its population, right? And that failure emanates, or can emanate, from a failure to ensure that everyone enjoys those protections without discrimination. That's a good understanding, I think, of the first preambular paragraph. The second preambular paragraph is to say refugees are, by definition, this relates to a discussion we had before the break, not a domestic issue. They're not a domestic issue because people have crossed an international border. They're no longer in the purview or the issue of one state. They are a concern, or they ought to be a concern, of the international community. And so that is why you've had the UN expressing in various instances its concern for refugees, and essentially its desire that they enjoy the widest possible exercise of their fundamental rights and freedom. It's also the case that the Refugee Convention came against the background of previous agreements. So from the end of the First World War, in the so-called interwar period, there was recognition that the consequence of that war, the collapse of certain empires, the creation of new nation states with large ethnic minorities that were often being despised by the new ethnic majorities in those states, the the effects of the October Revolution in Tsarist Russia and the creation of the Soviet Union. All of these things have led to people fleeing in various parts of Europe. This is all still within very much a European mindset. And as a result, those people needed forms of protection. And so there was a series of ad hoc protections in ad hoc agreements in relation to specific groups of Europeans as groups, right? Even though the protections were granted to individuals. And so the convention is not written against the background of no protections. It's written against the background of existing several forms of protection. And so the third preambular paragraph tells us exactly that. It says we need to revise and we need to consolidate those previous agreements um, and to extend the scope of a protection accorded by those instruments, because those agreements, by definition, only related to specific people at specific times from specific places. And the idea here was to universalize, as I said, with the proviso that the original convention, the 51 convention, extended it only to the European continent. But the same principle now applies globally. And so the agreements, the main agreements that preceded the 51 convention were agreements related to Russians and Armenians, to in ultimately to German and Austrian Jews, to Spanish Republicans who were fleeing the civil war in Spain, and various other small minor arrangements that are listed the in Article 1A1 to the Refugee Convention. So in this idea of people who are so-called statutory refugees, they had refugee status somewhere on some bases before. They held something called the Nansen passport, usually. So this first kind of concept of a refugee document invented by a Norwegian later Nobel laureate Fridtjof Nansen in 1922 and issued to hundreds of thousands of people across Europe in the 1920s and 30s to facilitate their presence and their ability to exercise rights of certain natures in certain European countries. So those frameworks existed, and so the Refugee Convention said we'll keep those arrangements in place, but for future people, right? So people who need protection who haven't got protection under one of those arrangements, we will create a refugee definition, which we're about to come to in a few minutes. So that's the understanding or the context of those paragraphs. So thus far, all good in terms of trying to do good things, right? To do kind of mother with an apple pie stuff that we want to be nice, we want to have rights for people, we want to extend arrangements. Now we come to the bit in the preamble where the drafters start facing the challenges and try to see whether they have managed to answer those challenges in the text of the convention. So the first of these challenges is this idea that, lo and behold, they understood in 1951 what we clearly understand in 2026 from our discussion before the break, that the granting of asylum may place unduly heavy burdens on certain countries, right? It may be, as a matter of fact, that certain countries will end up bearing the brunt, and that the satisfactory solution of a problem of which the UN had recognized the international scope and nature cannot therefore be achieved without international cooperation, right? So you read this paragraph, this is in the preamble, right? This is the start of the document. And you kind of think to yourself, well, I'm sure there's going to be a provision somewhere down the line in this treaty that talks about this international cooperation idea, right? That sets out how refugees are going to be distributed so that we don't end up with unduly heavy burdens in certain countries. But you read through to the end of the document and you don't find it, right? Because none has been reached, right? So there's been recognition that there's a problem, right? Or potentially a problem that certain countries will bear the brunt, that it's perhaps unfair, that this is an international problem, and it needs an international solution and cooperation. But to do that would have required states to cede sovereignty to a level that they were unwilling to accept, at least at that point in time. And so that didn't happen, right? So that's the first kind of gap between perhaps the desire and the reality. The second gap is, I think, a gap, some people disagree, is in relation to what it means to recognize somebody as a refugee. So the idea here was the drafter said, well, when you recognize somebody as a refugee, this issue or this problem, quote unquote, of refugees is a social and humanitarian one. And so countries, when they recognize somebody as a refugee, should do uh, everything within their power to prevent it from becoming a cause of tension between states. Because really, why would a state whose citizens have just been recognized by another state as refugees because that state deems the treatment they receive as persecutory, why would that state feel that should cause tension? I'm being, of course, a bit sarcastic here, right? I mean, to me, that is a recognition that, of course, that is very likely to happen, at least in certain circumstances. It's very likely to be the case that if a state believes the treatment of, say, a religious minority in another state, or a sexual minority, or of women, or of political dissidents, is at a level that meets the threshold for persecution under the Refugee Convention and grants them status on that basis, they are passing judgment on the behavior, the standards, the protection, the rights in another country, right? That, to me, again, as I say, it's a controversial point because some people don't see refugee protections through that lens, but to me, that is part of the course, right? That is partly what you do when you grant refugee status, right? So not other forms of protection. We'll come to those in subsequent seminars and that. I mean, there are instances where you open your border and there's no passing judgment involved necessarily. But this paradigm, the persecution paradigm of the 51 Convention, to me necessitates a degree of reprimand to the failure of another state to do what is right by its inhabitants or some of its inhabitants. And so I read this paragraph as saying, we actually know this would be the case, and we want to avoid that from creating too much tension between states. Ultimately, the history is that the maps that I showed you earlier is, of course, a map in 2026 or thereabouts. A few years after this treaty was adopted, it was still the case that the entire Soviet bloc was not party to this treaty. Soviet Union would not sign this treaty, and it became very much a source of tension, an ongoing form of tension, particularly between countries like the United States and the Soviet Union. The United States would often grant people who were political dissidents from the Soviet Union or other countries that were under its wider umbrella, the Warsaw Pact, protection on these grounds, right? So the context in which this um, politics and political implications or ramifications of refugee status come into its application, to me, is inevitable. But as I say, the drafters thought that that's a negative and wanted to reduce its impact at the very least. So that's the second thing, the second kind of source of tension. The third source of
So
tension.
to touch upon that, maybe
Sure, go
just
ahead. Sorry.
I was I heard that maybe there's like this kind of trend to try and create a way to not I guess openly state that the state that they came from has been doing something that is I guess some kind of poor conditions towards their people. Rather, they're trying to frame it as, I think maybe in Africa or something, they're trying to frame it as kind of a objective thing that the state is unable to deal with its internal affairs, and that's why they need to be supplied the refugee status.
Sure. So that's a really good point, right? So the first thing to say is that we will look in a few minutes at the refugee definition in comparison to definitions in other regions, including in the on the African continent, in the Organization of African Unity as it was then, the African Union as it is now, convention. And we will see that the definition there, beyond, it accepts the 51 convention definition, but extends it beyond two circumstances where there is no persecution involved, at least not as a criterion, right? But the criteria are what you call objective, right? So they relate to the events that are happening in the states that have an effect on the ability of the state to function in a way that allows people to live there safely, and hence people feel compelled to leave it. And that very well may be then a different frame, right? And in those circumstances, to grant somebody protection on these grounds is not a direct passing of judgment, right? In the same way, because it doesn't involve persecution. So I would absolutely take that point. I think also the the qualification to what I was saying earlier is that you can make the argument that when non-state actors are the ones who are um, responsible for the persecution ultimately, so think about gang violence in El Salvador or Nicaragua, or think about instances of female genital mutilation in certain rural areas in sub-Saharan African countries. Um, it might be that the state is actually um, would agree with you that the state nominally, that's where this is happening, would agree with you that as a decision maker that these are bad practices, and the state's just not capable of dealing with them, right? We'll come to that point a bit later. This idea of a non-state actors persecution, and then you might say it's not really passing judgment on the actions of the state, it's passing judgments on the effect that the situation the state is having on persons. That's a relevant distinction. I mean, I take this as a potential critique. My own view is that it is still passing judgment in those circumstances on whether the state is functioning as a state should be functioning, right? So ultimately, if a state is unable to face up to gang violence or to rural areas being ruled in a way that is not compatible with its state legislation, that is passing judgment um, on that state being fully functional. So it's the degree to which this is maybe even be a terminological debate, or what one means by judgment. But the provision here talks about something becoming a source of tension between states. And I think the question of whether something ends up being a tension, um, in the end relates to how the state of origin perceives the grant of protection by another state, right? Does it perceive it as it having helped some of its citizens in, say, a circumstance where they were subject to gang violence? Does it see them as that state essentially intervening in its internal affairs, right? Which, of course, refugee law permits it, mandates it, rather even to do, right? So refugee law, under my account, which we will come to of things like membership, particular social group, refugee law mandates a country to which someone fleeing the death penalty because of their homosexuality to grant that person protection, even though that is clearly passing judgment on the legal system in the country that they're fleeing and its the content of its laws. And it may very well cause tension between those two states. My own view is that that's tough, but I mean that is what refugee law is here to do. But I think it's interesting that that the framing of the convention was an attempt to almost mitigate the effects of refugee protection, right? In a way that perhaps is desirable from, if you think about it, you zoom out, you think, what are international instruments trying to do? They ultimately try to advance the UN general charters, general principles of peaceful relations between nations and the like, and perhaps see it through that lens. I'm not necessarily persuaded, but I think it's an interesting kind of analysis to engage. So as I said, the final paragraph here relates to this point that I made before the break about the absence of having any mechanism in the convention to enforce it, right? Or to adjudicate it in a way that is authoritative. So having a mechanism that tells us a state has interpreted this particular application by this particular woman in Senegal wrongly, right? And the interpretation has to be X and not Y, and the state has to reconsider or has to revise or change its decision. So regionally, certainly in the European Union, for countries that are members and follow the acquis or the body of law in the EU, the Court of Justice performs that function in relation to asylum cases, with the hope, at least in general, of maintaining harmonized standards across the EU for refugee protection. It's still the case that individual member states make decisions, and so it's still the case that divergence or variance exists greatly. But there is a body that, at least in principle, today performs this type of function. But globally, there isn't, right? And so the role that UNHCR was granted in this convention was not a role of a body that enforces the convention or that sets standards that are binding on states, but rather a supervisory role, right? So it's a role where UNHCR is an irrelevant actor, right? The United Commissioner for Refugees. It's one with which states have to cooperate. They fail to cooperate with is that is wrong from their treaty obligations perspective. But what cooperation means, um, is unclear, right? And is limited. And it does mean, I would argue that, for instance, if there's a case in a court and UNHCR wants to intervene as a friend of the court, right, as an amicus curiae, and to make the argument for a certain interpretation, then ordinarily states should allow it, right? They tend to, right? They did in Israel in some of the cases we'll come to next week on asylum seekers. There were UNHCR interventions. There's now there was a big case in the UK, which we will come to as well in a couple of days, about the so-called UK-Rwanda agreement, where UNHCR intervened, and it occasionally does. So that sort of role UNHCR can seek to perform, and when it does, UNHCR's aim is to harmonize standards. So UNHCR takes a certain or adopts a certain interpretation of what persecution means, of what social group means, of what in what circumstances cessation of status happens, in what are the circumstances under which one can expel a refugee. So UNHCR would have standards on all of those things, and its aim would be that those standards would be adopted by different states. So it's not the case that there is no attempt at international harmonization, but it is the case that the convention, unlike other bodies, think about the European Convention of Human Rights having the European Court of Human Rights, right, which has mandatory jurisdiction of individual cases now. I mean, that wasn't initially the case. So individuals can bring cases. Think about other regional courts in the Americas, in Africa, Think about even treaties like the ICCPR, so Covenant on Civil and Political Rights, has a committee which can hear individual communications. There's no mechanism for an individual to approach an international body to challenge a specific decision in relation to them in that form, right? That mechanism doesn't exist. Interestingly, that's the anecdotal point. There is actually a mechanism in the Refugee Convention that allows a state that is a party to the convention to bring a case against another state to the party to the convention. Some of you may think of another convention where a similar mechanism exists, where a case may have been brought in recent years. How many times do you think that mechanism has been triggered? So Article 38 of the Refugee Convention, allowing a member state to bring a case against another member state for arguable breaches of the Refugee Convention. How many cases of that nature have been brought before the ICJ?
I
Any
would
guesses?
venture that none. Zero.
Any other guesses?
Maybe only in the context of Syria or something, maybe like one case.
Yeah, so Liana was right. So it is zero, right? So no country has ever, in 75 years, brought a contentious case against another country for breaching the Refugee Convention. Think like, Canada could have brought a case against the United States, which remains a member of the convention, right? It doesn't give the ICJ general jurisdiction, as we know, since Nicaragua, but or some of us may know, but since the Nicaragua case in the 80s, but in this particular treaty, it's a mechanism that's built into the convention, very much like the mechanism in the Genocide Convention, right? And so, you could say what you're doing on the Mexican border breaches the Refugee Convention, which it does. Or, somebody could bring a case against Australia for its policies of pushing votes in between itself and Indonesia and PNG, or cases against European Union countries, or cases against Israel, or cases against others, right? No one has ever brought a case against another state, right? Which is fascinating and an interesting reflection, perhaps going back to that penultimate paragraph, right? That would certainly cause tension between states, no doubt. And that has not happened, right? So the culmination of all of this picture is that there is no global refugee court or effective mechanism to ensure harmonization of refugee standards globally. There is, however, a treaty, which is one treaty that most countries in the world have signed, that has a UN agency that is in charge of supervising, that has issued guidelines on multiple areas of law, handbook that is being used, a body of jurisprudence, and there is, of course, conversation across jurisdictions, judicial dialogue, as they often call it, transnational judicial dialogue between different jurisdictions, asking similar legal questions ultimately, and reaching ideally similar responses. Right. So the picture is complex, right? It's not it can't simply be, I think, stipulated that there is no international framework that is being enforced. But it's also not the case that we have a body with a binding global mechanism to enforce it, because we don't. And that kind of space between those two polar opposites, I think, is a particularly interesting one. It's not unique to refugee law, but I think it's very profound in relation to refugee law because of the impact that has on individuals and their ability to enjoy rights, or for trade states to treat them in a way that is compatible with the convention obligations. So what I suggest we do is we do a 5-minute break now, just to give us a bit of air. And then we'll come back to the last half hour or so, and we'll start looking at the refugee definition in comparison with the regional definitions. And I suspect that's roughly where we'll stop. And then we'll resume tomorrow with discussing the specific components of the refugee definition. So again, I suggest we reconvene at past and start there. So let's resume. So what I want to do is first to talk about a few general tenets of the refugee definition, sorry, the refugee convention more generally, and then we'll move to certain questions around the refugee definition and the way they, as I say, interact with or differ from regional instruments. So the first thing is this idea that there's a general definition of the terms. I say the previous instruments have all had a dimension that involved linking them to a specific group, either a specific region, a specific nationality, a specific ethnicity or religious group. And this here, the definition itself, as you will see, makes no mention of any of the above, right? And so it's on its face a general definition. It also now, having had the 67 protocol in place, applies sort of having the geographical and temporal restrictions removed. It really applies globally, right? And so to that effect, it is an international definition, and it's a standard that it imposes that is supposed to be a floor and not a ceiling, right? So the Refugee Convention is, as I say, there's a debate as to whether it is or isn't a human rights instrument, but irrespective of whether one stands in that debate, there have been subsequent human rights treaties that have given, in certain instances, individuals in certain areas of life rights that go beyond the refugee definition, right? Sorry, the Refugee Convention and the rights under it. And that's not surprising because later more elaborate instruments, and I mentioned the two main covenants, but we can think about other international treaties as well, on the elimination of racial discrimination, on elimination of discrimination against women, on rights of people with disabilities, Convention on the Rights of the Child, and the like. And so what the Refugee Convention does, and it's quite explicit on this in Article 5, is that it does not exclude the possibility, right? And in fact, it acknowledges that it is a likely possibility that there will be future human rights treaties. And if, to the extent those apply to refugees as persons, right, or as children, or as someone with a disability, or as a woman, or as someone who suffers racial discrimination, what have you, depending on the convention, then whatever rights they have under those treaties would apply to them, right? So the standards for treatment of refugees in the Refugee Convention to that effect are the minimum standards. Refugees have to enjoy their floors and not a ceiling, right? That's quite important. And then the perhaps most challenging but also fundamental component of the notion of a refugee under convention is that it is an individual status, right? So it's not a group-based type recognition, albeit there might be circumstances where many individuals, all from a certain ethnic group or national group or religious group or holding similar political opinions or what have you, suffer a similar predicament or a similar challenge. And so many of them might need the same protection and might seek it in the same place, right? And so for administrative convenience or efficiency, states might do something that UNHCR calls prima facie recognition, right? So on its face, kind of you recognize people if they meet categories A, B, C, D, as refugees, and you don't go through a lengthy kind of individual assessment. But the core is that it is individuals who seek protection here, right? And that every country can be a refugee host country, ought to be, one would say, but also every country can be a refugee producing country. So it's entirely plausible and predicted by the convention that even countries that have signed the treaty would themselves produce refugees, right? It's conceivable that there will be those circumstances. It's not ideal, it's not desirable, but it's conceivable, right? And so that's a form of response to this, is that the assessment is an individualized one. So that takes me to the second kind of general point that I want to make, which is about the structure of the convention. And when I introduced the module, I introduced some of the components that we're going to be discussing, and perhaps it's not surprising that all of these, in one form or another, will feature in subsequent seminars, right? So mostly tomorrow we'll be talking about the inclusion clause, right? About what defines a refugee as entitled to international protection? What are the specific interpretive challenges around this? That's Article 1A2, fundamentally. The cessation clauses then are clauses that concern when refugee status comes to an end, right? So what are the closed list of circumstances where, having been once recognized as a refugee, you no longer are deemed to need refugee protection. And because refugee protection is not supposed to be permanent, but is supposed to be a status between your previous status and your future status, right? Whenever it comes, cessation is entirely plausible, right? It's entirely consistent with the idea of refugee law in the way it's conceived. Um, and then the exclusion clauses and the contingent inclusion clauses, right? So those provisions that say these are the circumstances of people who don't need protection from the convention or don't deserve protection. And then finally, having set out um, where the entry points or exit points of the convention would be, the convention, the vast body of the convention is actually related to rights of refugees that are phrased as obligations of states, right? So um, the provisions in Articles 2 to 30, um, ultimately 34, with the exceptions of Article 33, which is non-reformer, which is also to some extent an obligation, all provisions that in one form or another pertain to things that states have to do for refugees or can do to refugees. So that's the structure of the convention. And the key thing to understand about the refugee definition, which is a point I made at the very start, is this point, which is set out in the handbook of UNHCR. And I will read it in full. It reads a bit like a repetitive sophistry, but it's actually, as I said, to me, one of the most fundamental bases of understanding refugee law and differentiated from other legal statuses. So what the handbook says, in essence, is the following. It says a person is a refugee within the meaning of the 1951 Convention as soon as he fulfills the criteria contained in the definition. This would necessarily occur prior to the time at which his refugee status is formally determined. Recognition of his status does not therefore make them a refugee, but declare them to be one. They do not become a refugee because of recognition, but they're recognized because they are refugees. Now, what does that essentially mean? The best way to think about it, this declaratory status versus constitutive, is to think about the difference between marriage and a phone, right? So the difference is simple. When a marriage is officiated, it changes the personal status of the people who are getting married, right? They are not married prior to having been married, and having had their marriage officiated in a way that is in accordance with the law, their status changes. So the marriage officiator, by marrying them, changes their status, constitutes them as married as opposed to being unmarried, right? This phone that I'm holding is not constituted by the fact that I say it's a phone. The reason I say it's a phone is because I recognize that it is a phone. And it's a good thing that I do, because I probably am less likely to then throw it or dispose of it or sit on it or what have you. But it was a phone before I said it was a phone. Just now, it existed as a phone. And so I declare it, as you were, to be a phone. Uh, but I don't make it a phone. It's already a phone. And the reason, and refugee status is more like a phone than it is like marriage, in the sense that if somebody has left their country of origin, they are outside that country, which we will see is one of the criteria for refugee status. They are now applying for asylum somewhere else. And let's say, as I said, they belong to a religious minority group that is being subject to horrendous treatment in their country of origin. And it's very clear that if they were to be returned, they would be persecuted within the meaning of the convention. So that reality becomes clear to the decision maker once they look through the application, they assess it, they decide it.
Can
There
I
was a
ask
period
you a
of time.
question?
Yeah, I'll just finish the example. There was a period of time between the time that person left their country and the time the decision maker made that determination that they meet the refugee definition. In that period of time, that person was a refugee. They were a refugee because they met the definition, the criteria under the definition of refugee. They were just not given that status yet by the decision maker. But they were refugees, and that's significant because it means they should be treated from the point at which they apply for asylum as if they are what we call in the jargon putative refugees or presumptive refugees. So they are deemed to be presumed to be refugees until proven otherwise. Because the reverse position would be to deny them rights that they may, in the end, be found to have been entitled to from day one. And sorry, go ahead.
Okay, thank you. Can I just, for example, if I leave my country where like in a free or in a good circumstances, like for, I don't know, to travel, and then I
Yes.
cannot come back to my homeland because I kind of like can I just become a refugee throughout time, not on like yes, can how is that like how can that happen?
Right. So I don't know if you were here, but I actually did discuss this kind of briefly, but I said I'll return to this point. So it's a good point. When we talk probably tomorrow about this notion of refugee surplus, and I've given the example of someone who leaves a country to go and study somewhere else, right? And gets a student visa. And whilst they're abroad on a student visa, things change in their country of origin to a level where they can't return to that country. They're now under threat in that country, right? When they left, they were not refugees. But as circumstances have changed, they now meet the refugee definitions. If they now apply, having been now in a country of their study for 2 years, they now apply for refugee status. At that point in time, if the assessment is, because refugee status is forward-looking, if the assessment is that at this point in time, if they were to be returned, they would be subject to persecution, then they are refugees, right? And so they are what's referred to as refugees sur place. So they have become refugees in place. So not to begin with, not as when they left their country of origin, but as circumstances evolve. Because refugee status is always forward looking. It's always asking the question. The decision maker always asks the question, what will happen to this person if I return them? That's by definition a forward-looking question. It's not a backward-looking question. Right? Does that make sense? Does that
Yeah.
no.
Yes. Thank you.
Yeah, so we'll talk about those types of specific examples a bit later, because it obviously also raises challenges, right? So one obvious challenge from a decision maker's perspective is that the worry is that people will take advantage of that, right? That people will come in not as refugees on other visas and will then attempt to change their circumstances so that they would be entitled to refugee status. For instance, um, would start practicing a religion that is prohibited in their country of origin or something. So there are interesting questions around this, which we will probe. But yeah, absolutely. The answer is that that model is by definition something that can happen in refugee protection. I mean, it can and does, right? So we can think about multiple examples in recent years of people who left at a certain circumstance their country of origin. Ukrainians, obviously, who left Ukraine before February 2022 were not refugees, then became refugees after. So yeah. And many examples. So which we can probe. Great. So after all of this anticipation, we were talking, we're skirting around the refugee definition without actually talking about it. So it's probably time to introduce it, right? So there are four components to the refugee definition, right? The first, which we've already been discussing at quite great length, is that refugees, in order to be refugees, must be outside their country, right? So as I've said, they don't have to be in another country in order to meet the rest of the criteria, but they have to leave, right? So you can't recognize somebody under the convention. You can under your domestic law if you have mechanisms that allow for this, but under refugee law, you cannot recognize at the moment, say, an Afghani woman persecuted by the Taliban as a refugee while she's still in Afghanistan, right? That the requirement, the textual requirement in the convention is that you are outside your country and that you then have a well-founded fear of persecution. And the fear of persecution, this is the point I made to, I think, response to Eviatar before the break. The fear of persecution needs to have a nexus, so a connection to one or more of five convention reasons, which are race, religion, nationality, membership of a particular social group, which is a category I'll come to in great depth tomorrow, or political opinion. And that as a result of that person must be unable or unwilling to avail themselves of the protection of their country. So you've got somebody who has left their country who says, if I were to be returned, I will be persecuted on grounds of my race. And if that persecution is by the state, then of course I'm unable to avail myself of the protection of that state. But even if it's by a non-state actor, right, we'll come to, I'm unwilling to take that risk that the state might not protect me sufficiently from that persecution, right? So that's the definition, and it's quite a narrow category of people who need protection for the reasons I can't remember who was asking or making this point earlier. Perhaps Itamar or someone else about mechanisms in places where I think it was in relation to our discussion of condemnation of states. Some people may need to flee not because of persecution, but because of other risks to their safety or their lives. And so they're not at least explicitly covered by this definition, right? So this definition is narrow and doesn't apply to everyone who needs protection. And that's precisely the reason in three regions of the world, there has been a recognition of that and an adoption of mechanisms which either extend the refugee definition itself or create alongside refugee status an additional status in the context of the EU called subsidiary protection, which extends protection to people who are not refugees but who still need to be protected from return. Right? So those three mechanisms in turn are the Organization of African Unity, or now the AU, or the African Union Convention, relating to specific cases of refugees in Africa from 1969, the Cartagena Declaration, decided or declared in Cartagena in Colombia in 1984, which is a non-binding instrument. It's a declaration rather than a treaty or convention, but it's been adopted or incorporated, or its contents been incorporated by many Latin American states into their domestic refugee law. And then, as I said, the European Union in its qualification regulation, which forms part of its wider asylum acquis, this regulation is actually about to come into force, but it repeats essentially verbatim the principles that existed in EU law for more than 2 decades in the qualification directive. So for all intents and purposes, I mean, the provisions I'm going to cite are from the new regulation, but it's essentially been EU law for the last couple of decades. So what do these definitions say? So if we look first at the OAU Convention, the OAU Convention says in 1969, that is, right? So more than 50 years ago, it says the term refugee shall also apply to every person who, owing to external aggression, occupation, foreign domination, or events seriously disturbing public order in either part or the whole of the country of origin or nationality, is compelled to leave their place of habitual residence in order to seek refuge in another place outside his country of origin or nationality. Right? So the first kind of obvious component where it's similar to the Refugee Convention definition is the requirement to be outside your country. Right? So it doesn't apply to someone who was displaced within their country. I will come tomorrow to why I've highlighted this either part or the whole of his country, right? This relates to a concept in refugee law called internal flight alternative or internal flight protection. So I'll explain why that's relevant. So we can park this for a minute. But I think what's important about this definition is to think about the circumstances where somebody should be recognized as a refugee, right? Extending the definition of a refugee to people who are displaced by things such as external aggression, occupation, foreign domination, or a basket category, really, of events that are seriously disturbing public order, right? And those types of circumstances, right? Serious disturbances to one's life in the country are ones that compel that person to leave that country in order to seek protection somewhere else, right? So there is a forced migration component here. There is a compulsion element, but there isn't a need to demonstrate, or at least not on its face, that that individual has been targeted specifically because of something that relates to their characteristics, right? It says nothing about what that person or why that person themselves felt they had to flee. Is it because of their religion? Is it because of their sexuality? Is it because of their gender? Is it because of their nationality? That's not the core of this extension. This extension speaks to the circumstances in which that person was forced to leave. And they're quite wide. And if we think about it historically, they relate to the time in which this was written, which is 1969. So this is the heart of the colonial or post-colonial struggles in the continent, on the continent of Africa. Many countries have been exactly just about to be released from foreign domination, are subject to external aggression, have witnessed occupation or otherwise, or are having events that are disturbing public order. These are all things that are happening on the continent and are deemed to be by these drafters, right? So this is 1969. This is 2 years after the New York Protocol extended the application of the convention to refugees outside Europe, but does not change the definition, right? So the global definition in 67 remains as it was, and people convene in Kampala and they say, well, we actually, in this continent, in Africa, need a wider definition of who is a refugee to reflect the challenges that we face in this region, right? So that's the OAU convention. The Cartagena Declaration does a similar move, right? This is 1984 at the height of um, various struggles in various countries in South America and Central America, often involving violations of human rights, involving disappearances of persons, involving fascist regimes, involving and attempts by external powers to remove leaders, to put in place other leaders, to support one side in a civil war against another. All of these things are happening on the continent. And so people convene in Cartagena and they say, we in Latin America need to enlarge the concept of a refugee. And in addition to 51 and 67, we need to include people who have fled their country because their lives, their safety or freedom have been threatened by, and there's again a list of slightly different types of circumstances. So some overlap, like events that seriously disturb public order or foreign aggression, but some are deemed to be unique to this region at that time, at that point in time, like internal conflict, like massive violations of human rights, and like other circumstances that seriously disturb public order. So we've got a similar move to extend the definition in the region for slightly different type of circumstances that correspond to what the drafters in this region thought were the concerns of this region that needed redress, right? I'll just skip the next slide. I'll come back to it tomorrow because I want to talk about the EU last, just in the last few minutes. The EU, in its asylum jurisprudence, has three types of statuses that are statuses that pertain to international protection. The first is asylum, which essentially is refugee protection within the meaning of the 51 Convention. The second is subsidiary protection, and the third is temporary protection. So we'll talk tomorrow about temporary protection, the status that was granted to Ukrainians. But I want to zoom in on subsidiary protection because there the move is a similar but different move to the one in Africa and in the Americas. So the move here is to say something different. It is to say persons who are eligible for subsidiary protection are people, uh, the EU jargon term here is third country nationals. So those are people who are not citizens of your country and are not citizens of another EU country, which are referred to as second country nationals. And so they are third country nationals, so countries of any country outside the EU, or people who are stateless, and in respect of whom there are substantial grounds for believing that if they were to be returned to their country of origin, they would face in that country a real risk of suffering serious harm, and their state and they're unable or unwilling rather to avail themselves of the protection of that country, right? Um, and the real risk of serious harm consists of these following things: the death penalty or execution, torture or inhuman or degrading treatment or punishment, and a provision relating to conflict, right? Serious and individual threat to a civilian's life or person by reasons of indiscriminate violence, right? So violence that is not meted against you because of your characteristic, right, which is what the refugee definition would require, right? It's because of your nationality, it's because of your ethnicity, it's because of your political opinion that you're being targeted by this bombing. So no, this is about carpet, indiscriminate bombing in your region, right? That poses a threat to you as a civilian, right? If those circumstances happen, then you don't get refugee status under this model. You get subsidiary protection. You get a status that is additional to refugee status that exists alongside it, that acknowledges that other people require forms of protection as well. And so there are differences here in terms of scope, in terms of terminology, in terms of justification, and there may be effects of this divergence, right? It arguably creates a form of hierarchy because there is one definition that is global. And if you're recognized in a region based on a regional definition, then it's not clear what that definition does to you if you were to travel outside that region. And there's a big question around harmonization, around does not being recognized in one country mean you can't be recognized in another? That's referred to as negative harmonization. So I want to return to that theme perhaps tomorrow when we talk about the different challenges of the fact that the refugee convention is self-applied and is applied in different ways by different countries. So I think this is a good point to end today, and we've also come to time. There might be questions, so I'm happy to stay for a few minutes if people have questions about this. Just see if anyone does.
I'm just curious about like people, let's say from the West Bank, who can
Right.
just, yes, they're not like they have their own jurisdiction in the West Bank, but maybe they can argue that they are persecuted or being under danger here in the current environment in Israel. So, what do you think about it?
So we'll come. I mean, I want to address this more fully than I'm able at this point, but I think the best place to discuss this will be in the seminar on Palestine refugees. I mean, the short answer is that some people from the West Bank are protected, are eligible for UNRWA protection, right? Those are people who were displaced from what has become Israel in 48 into the West Bank, right? And so, in certain circumstances, they are excluded from refugee status, but in other circumstances, they may become automatically eligible. There are most of the population in the West Bank actually was there before 48, and so they're not UNRWA kind of material, as you were. They can't be protected by UNRWA, which means that if they were to leave the West Bank and go somewhere else in the world, they would be assessed based on the refugee definition. So there might be a circumstance. I mean, I've been involved in a case of somebody who was accused of collaboration with Israel for selling land, and they were fearing retribution from neighbors without Palestinian Authority protection, and they were granted refugee status, on those grounds in another country. I can't disclose the details of the case, but so it's a complicated picture. There are Palestinians who are fleeing the West Bank into Israel on grounds of sexual orientation, and arguably should be granted protection if they fear persecution and no protection from the authorities there. Um, the question whether a country in the world would treat everyone fleeing the West Bank as potentially subject to persecution that requires protection, I think is a good one, right? Certain areas, the circumstances in, say, south of Hebron, right? For certain Palestinian communities, more generally, settler violence may, I think, raise serious questions as to the protection the Palestinians receive, right? So there are serious questions there. I don't want to try and give like an incomplete answer now, but I think you're raising an important question. So let's remember to come back to the West Bank as well as Gaza, when we get to that seminar later this week. Brilliant.
Thank you.
Sure. Any other questions before we close? If there are none, then I think we will end it there. I will stop the recording now.